members of the NSAC, Lord, I would like to humbly submit that these are Kenyans of integrity, highly professional, who have pulled themselves with their bootstraps and reached the echelon of our system, and it would be very unfortunate when it is left for their name to be sullied in the midst of a political context in which they have no interest. In fact, they were merely asked by the NSAC to send a message. A spokesman was appointed who went and sent the message, but they are now being tarred with the brush of having been trying to unconstitutionally alter a process which is sacrosanct and which they have sworn by their oath to protect in assuming their position. That's my humble submission, and I will donate the 3 minutes to the court. Thank you.
Thank you very much. The 3 minutes and 16 seconds are welcome.
Thank you.
Yes. Mr. Ngatia?
Thank you, Madam President. Please first allow me to introduce the lawyers who have burned midnight hours to present so many affidavits before you. My name is Ngatia Frederick. I'm assisted by the following lawyers: Mr. Kirago Kimani, Senior Counsel; Mr. Kioko Kilukumi, Senior Counsel; Professor Kithuri Kindiki; Mr. Katwa Kigen; Dr. Muthomi Thionkulu; Dr. Linda Musumba; Professor Kivuva Kibwana; Mr. Elias Mutuma, Melin with her; Mr. Edward Mureu; Mr. Hilary Sigei; Madam Monica Nyogutu; Mr. Collins Kiprono; Wanjiko Nyaga; Emmanuel Kibela; Caroline Cherono; and Chris Ayeko. Most of them are in court number 1, following the proceedings very intently. Madam, 8 petitions. It must be a new strategy to disable the president-elect to mount a defense against 8 petitions within 4 days. But we didn't manage the impossible, and we now present our defense as follows. First and foremost, my lords, let us appreciate that these consolidated petitions arise from a presidential electoral contest. It is an electoral contest. Ideally situated, or it should ideally be resolved by electorate, the Kenyan voters, not by a court of law. But because it is also part of the constitutional structure of this country, this honorable court is granted original jurisdiction by the Constitution to resolve this contest. But in resolving this contest, it is necessary to bear in mind that all you have are affidavits filed by the contestants. The difficulty with affidavits is that one can structure fiction and peddle it as a pleading, as I'll be demonstrating. I will start with Article 38 of the Constitution because to me that is the beginning of an understanding of this contest. Article 38 is the one that empowers a Kenyan to vote by secret ballot. And that simple sentence can be broken into two parts. Voting by secret ballot, meaning it confers on the individual power to exercise a freedom of choice unhindered by anything. Number two, or the second part of it, the vote gives the citizen a power or a badge of dignity for self-actualization. Self-actualization in the sense that a voter is entitled to vote for a candidate of their choice. Article 38, to my understanding, therefore becomes the beginning of the understanding of the correct situation that is before this court. It is common ground, and this is important, my lords, that on 9th August, voting took place everywhere in this republic. There is not a single place that presidential election was not held. Even in Kakamega, Mombasa, presidential elections were indeed held. There is no area in this country that did not participate in that voting. Accordingly, legitimacy, I go to the next point, legitimacy of any electoral victory is predicated on the fact that voting did in fact take place. From Article 38, one then goes to Chapter 7 of the Constitution, from Articles 31, going all the way to Article 81, going to 87, which donates a power to Parliament to legislate on elections. I would immediately say this, Madam Chief Justice. The power to enact Elections Act, to my mind, relates to the 5 other tiers of elections. For the simple reason that for the presidential contest, the inquiry is defined in Article 140. The relief is defined in the same article, whereas in the other levels of elections, one could look at the Elections Act. But I'll come to that a little later. I'm doing first and foremost a broad introduction of the areas that we'll deal with. As I indicated, the scope of inquiry of a presidential contest is defined in Article 140. Before you are 8 petitions. They have mutated. Now they are 7. Oh, very well. Thank you. They have mutated to a large extent, particularly the primary petition. But my request at this early stage is this, that when you retire to consider your judgment, please carry out some surgery, see the mutations which have been added, remove them so that you are left with the original inquiry under Article 140. Why it is necessary to do so is because other things have been infused in this inquiry, like who is to be punished, who is to be castigated. Those are not matters that can be dealt with within the purview, limited purview of Article 140. As a matter of fact, when we argued Raila 1 in 2013, this apex court said a petition under Article 140 should be, I quote, concise, precise, and well-focused. Well-focused. It cannot be a meandering, never-ending saga involving other persons other than the inquiry which is specified in Article 140. As I indicated, since elections were held everywhere, that legitimacy then translates to the following. The people of Kenya did express their sovereign will. They did express that on 9th, and what is now under inquiry is whether that sovereign will by the 14 million Kenyans is to stand unhindered, or whether this court would consider any other remedy other than upholding the sovereign will of the voters. Madam Chief Justice, just barely 2 years ago, Ghana was in the same position that this court is in. They held their elections. A presidential candidate went to the Supreme Court. Identical complaints were made. Complaint number 1, ballot stuffing. Complaint number 2, votes ought to have included rejected votes. Identical with the complaint before you. Complaint number 3, the chair lady was not being fair to the losing candidate. Identical things. And what is now happening in this new space is that we are all getting the drafting skills of our colleagues in other jurisdictions. Dumping and staging, we learned of it in America not too long ago. It is now before you. Ghana, 2 years ago, had identical complaints with the complaints which are before you. I pause before I go to the Ghanaian way of resolving this dispute to acknowledge my good friend, the team leader, Mr. Senior Counsel Orengo. He started by saying his case is not based on conspiracy. And he had to do that disclaimer for a good reason. It is the reason that, other than conspiracy, there is no case. And I'll come back to that in a moment. I go back to Ghana. Ghana considered all the evidence that was adduced, and the Ghanaian Supreme Court came to this conclusion, that the work of the court in a contest of this kind is to look for a substantive truth. I underline the words substantive truth of the elections. Look for the substantive truth of the elections. That's their Ghanaian approach. Then if you look at you are able to ascertain the substantive truth of the election, then the next very important values, they call them values, is to try to get finality and stability. Substantive truth of the elections, Next layer, finality and stability. Why is there need for finality and stability? The whole purpose of these elections is actually to underscore our democracy, to have a government in place for the next 5 years, and then we'll have yet another round of seeking the voters' validation of who will form government. I emphasize the finality and stability because at the end of this contest, what will be bothering this honorable court, if I dare say so, it is what are the reliefs to be given. Elections are carried out by our good Kenyans. I said in 2013, I repeat it again, we are unable to inculcate amongst ourselves the culture of accepting the electoral result. We are just unable to do that. Maybe it is in our psyche, maybe it's in our makeup, but we are unable to do that. Because we are unable to do that, we must then come to this honorable court to try and resolve that dispute in a very unfair way, because the dispute ought to have been resolved by the electorate. In my submission, when you look at this case, devoid of lawyers' arguments, you find it is based on certain planks. Plank number 1, Form 34A was hijacked mid-air, altered, votes from one candidate, losing candidate petitioner, removed, added to the votes of respondent number 1. That is a major plank of it. The easiest way to look at it, because I do not have the ability of Mr. Mahat, who dealt with technology, is to look at it from a point of logic or the antithesis. The antithesis being this: if that is true, from a point of logic, show us one Form 34A in the public portal, because that is where ultimately it landed, which differs with the hard copy at the polling station. Show us only one. Or show us a ballot box that people from outer space came and voted into, stuffed into it, and then all this hijacking in midair took place. There's no such evidence. And why there's no such evidence is because that is the work of fiction. Work of fiction, not just conspiracy, but work of fiction. In my submission, therefore, amongst the many things this court is now being called upon to do, is to find a way of moderating, I use the word moderating now in the correct sense, the excesses in the political contestants. Excesses such as imagining that this Supreme Court can now take over the role of voters and do a court coronation of any candidate. That would be a heresy. I will be dealing with the reliefs much later. I'm just doing a broad outline. And the next broad outline I would wish to do is to indicate to this honorable court that the orders sought in the primary petition, apart from being contradictory, would take this country to a constitutional crisis. We now have the incumbent in office with the limitations in Article 134. Limitations which are set or cast in stone by the Constitution. The incumbent in office cannot even appoint anybody to take over from any of the public officers being vilified before you. If, for example, and I say for example guardedly, this honorable court were to even countenance anything other than stability and finality, then a constitutional crisis would be triggered because the petitioner has repeatedly said he will not participate in an election held by IEBC under the chairmanship of Chebukati. We have adduced that evidence in the replying affidavit sworn by the first respondent. That replying affidavit is before you. It was filed on 26th August. We have attached a clip of that discussion. It's in an affidavit by Samuel Githae of the same date, 26th August, and all those are matters that are before you. Since the petitioner will not participate in a fresh election, does not want to accept defeat, then what does he offer? What is the solution he offers? The solution he offers is that there be an election presided over by the vice chair lady of IEBC. And only one needs to state that to see the crisis that this country will be engaged in. It will be a crisis of monumental nature, a crisis that I do not think that you would want to play with that kind of fire, because it will be fire upon fire. In my submission, therefore, I would request this honorable court, as we begin our submissions, to bear in mind how Ghana resolved an identical situation by, number one, looking for the substantive truth, and then immediately that should trigger a relief which is finality and stability. If this honorable court were to do that, I see a future for us. Any other solution, the crisis offered by the petitioner cannot be a crisis that this court can countenance, because your fidelity is not to anybody other than the Constitution. Since your fidelity is to the Constitution, I dare say then the reliefs that you could consider are the reliefs within the constitutional structure of this republic. With those comments, Madam Chief Justice, allow me to invite the first counsel to present, who is my good friend, Mr. Katwa Kigen. Mr. Katwa Kigen will deal with issues 1, 2, and 3.
May it please, Madam President, my ladies, may it please you, my Madam President, my ladies, my lords. My name is Katwa Kigen. I propose to deal with issue number 1, 2, and 3. And may I indicate that in dealing with those 3 issues, I'll be dealing with them together with Dr. Mudomi. My lords and my ladies, the 3 issues are to this effect. The first issue relates to the integrity of the technology, and the wording of that issue is whether the technology deployed by IEBC for the conduct of 2022 general elections met the standards of integrity, verifiability, security, transparency to guarantee accurate and verifiable results. The second issue relates to the question of whether there was interference with transmission, and it is to the effect whether there was interference with the uploading and transmission of Form 34A from the polling stations to the IEBC public portal. And the last issue that we will be dealing with Dr. Mudomi is the question of whether there are differences in Form 34A, and the wording is whether there was a difference between Form 34A uploaded to IBC public portal and the Form 34A received at the National Tally Center and Form 34A issued to the agents at the polling stations. Now, my lords and my ladies, some of the issues that I will be discussing, or rather some of the issues we'll be discussing with my learned colleague, are issues that have been discussed, but we must mention them, especially considering what the petitioner in the petition that we are dealing with, the one by Honorable Raila, states at paragraph 35 of his petition. And in that petition, I'm just reading the second sentence of that plea, where he states, the evidence shows that the acts complained of were committed by third parties, senior employees of IBC, acting in connivance with the second respondent in order to achieve a predetermined outcome in favor of the ninth respondent, and the ninth respondent for purposes of this petition is the first respondent. And so we are coming from the position that we maintain and insist that there was nothing that the first respondent did that could be said to have exceeded or to have amounted to collusion with the IBC. And I would like to start my submissions by reference to the issue of Form 34A and what the first respondent and the second respondent did. My lords and my ladies, in Maina Kia, it was determined that Form 34A is for all practical purposes cast in stone. What Form 34A contains is the last word in respect to the wishes of the voters in the given polling station. And if it has to be in any way impeached, it is only when it has been brought to court. And so in recognition of that, the first respondent, as allowed in law, availed his agents at the polling stations to participate and watch over the process of the elections. And we wish to emphasize that the place of agents is a very material part of this petition. It is going to be a very important issue in your determination of this petition, because the bulk of the evidence in respect to the issue of Form 34A in this petition is the allegation by one Arnold Ochieng, an advocate, saying that he received Form 34As which showed that the data in the Form 34A in the public portal, the data in Form 34A that the agents of the petitioners had, and the data in Form 34A that were brought by the returning officers to the National Tally Center were different. And so the question of whether or not there were agents, whether they could be trusted, and so on and so forth is important. But for purposes of the first respondent, we wish to maintain the position that he had agents, and those agents are failed to him from 34A through his lead agent. And after the Form 34As had been filled at the polling station, and all the agents available had been invited to endorse and confirm that the data captured in the Form 34A were true and accurate. After that had been done, the first copy of the Form 34A was then transmitted to the National Tally Center, the public portal. The other one was then taken to the National Tally Center. Now, I just want to emphasize two issues in that. One is that both the parties for the petitioner and the parties for the first respondent, had a chance to participate. The second thing I wish to emphasize, my lords and my ladies, is that in the entirety of the petition, none of the Form 34As at the point of the polling stations have been presented as having been challenged at any point. So that then the irresistible conclusion that should be made from the point at which the Form 34A originates is that those Form 34As represented an accurate state of affairs at the polling station, both in terms of data and in terms of the integrity of the process of voting and the counting of the votes. And as I said, then the Form 34As find their way to the National Tally Center, both in terms of transmission and the physical delivery by the returning officer. Again, agents for both parties were given a chance, and as allowed in law, the first respondent made sure that he had representation of his agents and has presented some of those agents to vindicate and verify that the data that was eventually verified at the National Tally Center were the accurate data of what happened at the polling station and passed on to the National Tally Center. I would like also to emphasize that the two things that were supposed to be done at the National Tally Center was to determine the data, and secondly, to establish the security features of the Form 34As. Having said that, my lords and my ladies, and considering that especially at issue number 3, your attention is on the propriety and the integrity of Form 34A, I must submit that the petitioners have not adduced any evidence of any challenge of any Form 34A at any point in the national tally. And this is the second chance they have, having had an initial chance at the polling stations. There is none of the Form 34As that have been challenged. It is with this state of affairs then, and as a result of this process, that eventually we have the declarations of the result coming out to indicate that the total valid votes cast were 14,213,027, being a product of a process that was interactive and where all the parties were involved. It is a product of this process also that comes out with the result that the first respondents' total votes were 7,176,141. Now, the process of verification of the Form 34As before they were transposed to Form 34C is a process that took 6 days. And over the period, all the 6 days, my lords and my ladies, as I already indicated, there was no objection to the verification of the Form 34As. It is our submission, my lords and my ladies, that the petitioner, through his agents, were happy with the process up to the last minute when the tallies were done, and it reflected a win for a party other than the one they wished. So that the reluctance and even this petition is based on objection as to who the Kenyans had wished to be their president. Having said that, then I would like to move on to the main party who has challenged the Form 34A. The witness the petitioner has brought for purposes of challenging Form 34A, being one Mr. Arnold Ochieng, and especially all the respondents have referred to him. Probably I shouldn't miss the opportunity to mention that Arnold Ochieng is an advocate. And some of the criticism we have about his affidavit and what it contains is to be looked at with the higher regard of the fact that being a lawyer, he should know more. One, my lords, he has sworn the affidavit and attached Form 34As when in his affidavit he acknowledges he was not an agent at any point. And so it brings in the point that that affidavit and what he says is hearsay. Number two, he produces about 20 Form 34As, and in all of them, he does not mention the agent who gave him. He does not say, I received. He says this Form 34A is defective because it has data that is at variance with the public portal. It is at variance with Form 34A that was brought to the National Tally Center. But he does not say at any point which of the agents gave him that Form 34A. Number three, he brings the Form 34As and says they were given to him in terms of either photocopies or photographs from the agents who were on the ground because he was not there. But he does not produce a certificate of electronic evidence to show that those agents have confirmed that indeed this Form 34A was properly generated and is capable of being treated as evidence of any property value in the consideration of your case, of this case, sorry. And lastly, my lords and my ladies, Mr. Ochieng then certifies